The topic of Group 9 is Hague Convention for the Pacific Settlement of International Disputes. The title of the treaty is Convention for the Pacific Settlement of International Disputes, also known as Hague Convention 1. The rationale for this is the sincere desire to work for the maintenance of general peace, to promote by all the efforts in their power the friendly settlement of international disputes, recognizing the solidarity, uniting the members of the Society of Civilized Nations, and of extending the imperial law, and of strengthening the appreciation of international justice. So it is a formal institution for the Pacific settlement of international disputes. The Hague provides a permanent panel of names from which the parties could select the commissioners. The task was to facilitate the solution of disputes by elucidating the facts by means of an impartial and conscientious investigation. The Hague Conventions of 1899 and 1907 are a series of international treaties and declarations negotiated at two international peace conferences at The Hague, Netherlands. Along with the Geneva Conventions, the Hague Conventions were among the first formal statements of the laws of war and war crimes in the body of secular international law. A third conference was planned for 1914 and later rescheduled for 1915, but it did not take place due to the start of World War I. The first Hague Conference came from a proposal on August 24, 1898 by Russian Tsar Nicholas II. Nicholas and Count Mikhail Nikolaevich Muravyov, his foreign minister, were instrumental in initiating the conference. The conference opened on May 18, 1899, the Tsar's birthday. The treaties, declarations, and final act of the conference were signed on July 29 of that year, and they entered into force on September 4, 1900. What is referred to as the Hague Convention of 1899 consisted of three main treaties and three additional declarations, which include the Convention for the Pacific Settlement of International Disputes. This convention included the creation of the Permanent Court of Arbitration, which exists to this day. The section was ratified by all major powers and many smaller powers, which consists of 26 signatories in all, including Germany, Austria-Hungary, Belgium, China, Denmark, Spain, and the United States, Mexico, France, the United Kingdom, Greece, Italy, Japan, Luxembourg, Montenegro, the Netherlands, Persia, Portugal, Romania, Russia, Serbia, Siam, Sweden and Norway, Switzerland, the Ottoman Empire, and Bulgaria. The purpose of the convention is the maintenance of general peace by, in a way, that the contracting powers agree to use their best efforts to ensure the pacific settlement of international differences. The pertinent provisions of this treaty is 1. Article 1. With a view to obviating as far as possible recourse to force in the relations between states, the contracting powers agree to use their best efforts to ensure the pacific settlement of international differences. Article 2. In case of serious disagreement or dispute, before an appeal to arms, the contracting powers agree to have recourse, as far as circumstances allow, to the good offices or mediation of one or more friendly powers. Paragraph 3 of Article 8. In case of a definite rupture of Pacific relations, these powers are charged with the joint task of taking advantage of any opportunity to restore peace. An international commission of inquiry is instituted as agreed by the parties when points of facts need to be settled, based on Article 9. Article 15. The International Bureau of the Permanent Court of Arbitration acts as registry for the commissions which sit at The Hague and shall place its offices and staff at the disposal of the contracting powers for the use of the Commission of Inquiry. Based on Articles 37, 38, 41, and 42, the first step in settling dispute of legal nature is through diplomacy. If it failed, the recourse is through arbitration by the Permanent Court. Otherwise, the parties will institute a special tribunal.
Now that we have tackled about the overview and the pertinent provisions of the Hague Convention, we will now go to its signatories and the significance of the convention to the Philippines. The convention originally had 26 signatories in all, and as you can see from the screen, these are all the signatories of the Hague Convention for the Pacific Settlement of International Disputes. The Philippines was not included in the original signatories. However, it is included in a number of ratifications as of May 2016. It includes these countries enumerated. The significance of the convention to the Philippines. The Hague Convention mandates a friendly settlement of international disputes. It also mandates international arbitration for its object of the settlement of disputes between states by judges of their own choice. It is also a recourse to arbitration, which implies an engagement to submit in good faith to the award. The rationale behind the convention is to promote by all efforts of the state the friendly settlement of international disputes, recognizing the solidarity which unites the members of the society of civilized nations and of extending the empire of law and of strengthening the appreciation of international justice. As we all know, the Philippines acceded to the Convention for the Pacific Settlement of International Disputes, establishing the Permanent Court of Arbitration, and most notably, the Philippines brought its maritime disputes with China in the West Philippine Sea to international arbitration. The South China Sea arbitration was initiated by the Philippines as it involves the characterization of certain maritime features and Chinese actions in the subject maritime area.
The Hague Convention for the Pacific Settlements of International Disputes. Um, Now that we have tackled the overview, the pertinent provisions of the treaty, the significance and signatories, let us go to the impact of this treaty to the international community. So what is its impact to the international community? The Hague created inquiry as an essential part of dispute settlements as it established the fact findings that both parties generally accept. The two Hague Conventions of 1899 and 1907 established commissions of inquiry as formal institutions for the Pacific settlements of international disputes. They provided a permanent panel of names from which the parties could select the commissioners. The task of a commission of inquiry was to facilitate the solution of dispute by elucidating the facts by means of an impartial and consensus investigation. Um, One of the common obstacles preventing the success of a settlement of a dispute by negotiation is the difficulty of ascertaining the facts, which have given rise to the differences between the disputants. Now, the the Hague will provide a um, permanent a formal institutions for the Pacific settlements of international dispute. The parties, however, are not obliged to accept the findings of the inquiry, although they always do accept them. The utilization of inquiry has been evident in the practice of international organizations such as the United Nations and its specialized agency. Inquiry has been used as part of other methods of dispute settlements. What are the criticism about the treaty? The first one is the small number of usage inquiry or fact finding. The procedure established by the 1907 Hague Convention proved to be successful, but it has been used in a very small number of cases. It was replaced with other fact finding techniques used by international organizations such as the UN or previously the League of Nations. Some of the specialized agencies of the United Nations have also adopted other techniques. The reason behind this is that the Hague Convention mainly applies its rules to exclusive choice of court clauses or agreements only, and hence it resolves the problem of parallel parallel proceedings, making international litigations a little bit more predictable, certain, and cheaper. The second one is that a useful deterrent for violent conflict, but not recognized by all. It is a useful deterrent for violent conflict, but not recognized by all, especially the powerful countries. Only 71 states have made a declaration recognizing the ICJ's jurisdiction as compulsory, or 30% of the UN's 193 member states. Furthermore, many powerful countries, including the United States, Russia, China, have not acceded to the Rome Statutes, um, um, distrusting and are discontented among smaller countries toward international criminal justice. The Hague-based tribunals can have a deterrent effect and aid in prevent violent conflict and abuse of power by countering impunity. However, as I've mentioned before, only 37% of the UN's 193 member states have declared their recognition of the ICJ's jurisdiction. What are the current news articles about the treaty? The first one is the India being not a signatory to the convention. The government had been of the view that the treaty, which is the treaty on child abduction, could lead to harassment of women escaping marital discord or domestic violence. The link is provided, as you can see on the presentation. The second one is Syria facing sanctions at chemical weapons watchdog. You can read the link as provided or as shown in the presentation. That's all. Thank you.